How is life? I hope you all are getting ready for NSING Prelim. Mains result has already come out, and Prelim is going to happen in June. All the states are slowly withdrawing their COVID related restrictions, and that is a very clear indication that this time no chance to get Prelim postponed. So get ready, and after Prelim and between main, the time never becomes adequate to complete some time, and for all the papers, mains papers. So therefore, whenever you get some time or you wish to get a break from your Prelim preparation, give some time for the mains papers also. And these lectures are also with that objective in mind, so that you get quick insights on certain topics of general studies too, which is known as polity, and that may help you definitely in mains but also in Prelim. So today the topic is very interesting. That is called the Representation of People Act 1950 and 1951. Okay. This is the act which has same name, but there are two acts. One is 1950, another is 1951. Okay. And the questions also come from this subject. Now, the Representation of People Act 1950, both the acts have been enacted before the elected parliament was in place. According to the understanding earlier, the Constituent Assembly, which was an elected body, of course, and that has been also given status as a parliament, okay, but not full-fledged parliament. Temporary position they are given to enact certain essential laws, okay, and that with that capacity, okay, these two acts were enacted. One is 1950, another is 1951. Right? So 1950 is a small act. Okay, it first opens up because you are coming from a colonized country, then you have to go to the independent country. Okay. Now, in that independent country, according to the need of the country, parliament will be formed. Okay. But how you will form it? Okay. So these two acts played a very, very crucial role to make your independent India a legal entity. Okay. So this is its main contribution and role. The first act, 1950, that is 32 sections and 8 parts, and it gives the number of seats, allocation of seats, okay, and then delimitation of various constituencies, because if you want to go for parliamentary elections, what do you require? You require constituency. But how to define the constituency? That means if somebody has to define it, there should be backing of law, and this act creates that background. Okay, then the election commission and the election conducting authorities will be able to act. So it gives the delimitation of various constituencies, and delimitation is the process of redrawing boundaries of Lok Sabha, okay, and state assembly seats. Okay. Lok Sabha constituency and legislative assembly constituencies are never identical, they are different. So that demarcation, that geographic demarcation, demographic demarcation, how to be done, it requires a approval, permission, and Act gives that permission. In the population, delimitation exercises took place in 1952, 1963, 1973 and 2002. So in various years, finally these delimitation, okay, the constituencies area demarcation, those things finally happened. 1951 Act further elaborates it, right? It makes 171 sections and 13 parts. So automatically you see that it is too large. That means earlier there were 32 sections, now another 171 sections come. They don't replace them, they are there, now some additional thing comes and then 13 parts come. Provision for the actual conduct of election. Okay. Now what we have seen earlier, that number of seats, constituency, delimitation, those areas they are giving power. Now it actually gives power actual conduct of election. Now you have to go for conducting the election. The corrupt practices and election offences, what is corrupt practices, what is election offences, who can be a candidate, when a candidature can be disqualified, all these things are now coming in a comprehensive manner in 1951 Act. So election related disputes, there can be controversy, somebody can go to the court, all these things have to be settled. So all these things finally the second Act is taking care of. Limit of election expenditure on campaign, okay, this is also another area, and you are not a law student, therefore there is no need of giving the details of the law unless that is essential. But in this case, I always say for the GS polity candidates that always a constitution related area or act related area, you definitely make a reference to the sections in the case of constitution's articles and related cases. Try to combine them. Okay. These all are actually citations that enrich your answer or improve the quality of your answer. So in this case, Kanwari Lal Gupta and Amarnath Chawla 1974 case can be a good citation. Now, how is the link of Constitution and Representation of People Act? Article 327 and 328 of the Constitution confers the power on Parliament and state legislature respectively to make rules for election to Parliament and state legislatures. Now what we find that there was a Constituent Assembly who are empowered to draft the Constitution, then there is Parliament, okay, and that Parliament approves that, and after Parliament approves it, then Constitution gets validity. Based on Constitution, now whatever power is given or attributed to Parliament, then Parliament starts acting on it. And what Parliament can act? Parliament can confers the power on Parliament and state legislature respectively to make rules for election. So that is what Constitution gives. Which articles? That is 327 and 328. Now Parliament will be coming into the picture. Parliament of India had enacted two acts. Representation of People's Act, that is 1950 and 1951, to provide a detailed framework around free and fair election of the country. This background will be always helping you to make a good introduction of your answer. The 1950 law makes provisions for allocation of seats in Lok Sabha and Legislative Assembly, this delimitation of constituencies, qualifications of voters, who will be voters, right? Particularly in 1950-51, you just imagine that inflow of refugees, then princely states, then various areas may not be fully within the enumeration, within the fold of administration. All these things now you have to decide who can be the voters. Qualification of voters, manner of filling the seats of Rajya Sabha. Now Rajya Sabha is coming second chamber. Now even the states are not properly done, how the Rajya Sabha will be constituted. So that is another concern. By union territory representatives, now union territories are there, which were earlier known as administrators area. Now that also should have representation in the Rajya Sabha. How many of them? Small union territories. How to decide that? All these things are becoming a concern, and these acts are trying to respond to them. The 1951 law makes provisions for conduct of elections to Parliament and state legislatures, qualifications and disqualifications, various offences, various doubts and disputes, etc. Now, what is the focus of RP Act? Constitution, then the Act comes, and then it looks into three areas. One is electorate, that is voters, then legislatures, which is Parliament and state legislation, legislative assemblies, and representative, who will be actually elected. Okay. Now, how that can be synchronized, how that can be really made to happen. This is where the contribution and significance of these two acts lie. Over the period, these two acts have gone through several amendments. 1950 does not require, because 1951 Act itself is an amendment and elaboration of 1950 Act, but 1951 Act has gone through several amendments over the period. You see 1966, 1988, 1996, 2002, 2008, that means at regular frequencies. What are the amendments make? Disputes are heard by High Court and Supreme Court and not by tribunals. Countermanding of election for both capturing and voting machines. Then insult to national flag and national anthem, election observer, provision of election observer it brings. Then right to information about candidates' antecedents. Then exit poll declaration only after all phases of voting is completed. All that you see, in election related, areas, these are all brought in through various amendments, and each amendment is adding certain new dimensions, new components to the Act. Then 2010, the amending Act conferred voting rights to citizens of India who are absenting from their places or ordinary residents in India. So those who are away from their constituency, how they can also be given chance to cast their vote. That came through 2010 amendment. Then 2013 amendment, a person in jail or in police custody can vote, and hence an elector. Supreme Court turned it down, saying who cannot vote cannot be elector. So this then therefore becomes an interesting area, because the amendment says that when a person is in jail or in custody can still remain an elector, but the Supreme Court turned it down, and that amendment gets nullified because it says that who cannot vote and cannot be elector either. 2021, so Aadhaar number may be requisitioned for further authentication. So that is the latest one which has been brought in. So when somebody is reaching the polling booth, the officials there, they can ask for your identity, and for that they can ask for Aadhaar number. So these are all various amendments introduced over the period. 4 major jurisdictions of the Act. Which are the areas on which this Act functions and remains relevant. One, with reference to the constitutional provisions, is minimum age, section 36 to 25 years to become a vote, what do you call, a candidate in an election constituency. That is explained in section 4D 5C, that which constituency he must belong to. Then state, for legislative assembly belonging to specific state, but for parliament there is no bar. Then preference of seat, reserved category, unreserved category. There are 4 major jurisdictions of this act. Fine. 1, qualifications of elected representative with reference to the constitutional provisions. Minimum age 25 years to become a candidate. I have given the section also in the bracket. Then constituency, section 4D 5C. Always try to see that you give sections also, because that is a good citation. Then state, for legislative assembly one has to belong to that state, but for parliament election there is no bar. Then preference of seat, there is reserved category, there is unreserved category, accordingly one has to move. Then conviction, if somebody is less than 2 years of conviction, then that person has no bar to contest an election. It has to be 2 years or more, then only there is some restriction. Merely a conviction doesn't mean that the person cannot contest election. Secondly, this conviction should be of serious type, not normal traffic violation and that kind of situation. It should be a serious crime, then only somebody is prohibited from contesting the election. How many seats one may contest? Maximum 2 parliament or legislative assembly. Nobody can contest number of seats, only 2 seats one can contest. So this is what is the provision about. Second one is disqualification, and questions also come very often on disqualification. In the Constitution, which are the articles dealt with is Article 102, 191 of the Constitution. This is regarding office of profit, then unsound mind, insolvency, then not a citizen of India, then criminal conviction, that is what we discussed earlier, and or declared disqualified by any law. If a person is declared otherwise, not conviction, but otherwise declared not to contest an election, then also that person is barred from contesting election. Then 10th schedule or anti-defection law. Then finally 10th schedule has been there, and the anti-defection law is also in place. Now RP Act, section 7, it says meaning of disqualification, appropriate government. Second, section 8, it talks about conviction of certain offences. Always remember, not all offences, but select offences. Section 8A is corrupt practices. Section 123 enlists details of that corrupt practices which can prohibit a person from contesting election. Then cases, here also you can give one case is K. Prabhakaran versus Jairam, and there is another very famous case called Lily Thomas case. So these 2 cases definitely you can give or mention as citation. So this is how your thing will go. Third one, no, this continues further. So there is section 9. Section 9 says about dismissal from government services for corruption or disloyalty. Section 9A for contract with appropriate government. That means if a person is already a representative and again he is making a contract with government by his own capacity, or any company where he is the person, then also that becomes a matter of disqualification, definitely subject to inquiry and confirmation. Then section 10 is office of profit, which I said earlier, holding office in government company. Then section 10A, not filed ITR return of the election expenses. So not that other ITR, but ITR related to election expenses has to be filed in time, otherwise that can be a ground for disqualification also. Section 11, reduction of the period of disqualification. Now disqualification cannot be uniform, that that depends upon the context, situation, how grave is the crime or how grave is the offense. Accordingly the disqualification will be defined. Therefore disqualification will certainly vary from situation to situation. Next is deciding on number of seats in the legislative bodies. The 42nd Amendments Act, Amendment Act 1976, frees the number of seats of Parliament and the seats allocated to the state legislative assemblies for the Lok Sabha till 2000. That means whatever is the total size and number of Parliament, that has been freezed till 2000. So that is what 42nd Amendment does. 84th Amendment Act 2001 further extended that period and it made it till 2026. But the basis of delimitation will now be 1991 census instead of 1971 census, that constituency definition, what will be the population size. So it has been extended from 1971 to 1991 now. So this is where does it stand. Then the issues involved regarding the number of seats, that is total number of seats, okay. Then constituency's jurisdiction, what will be the area of constituency, that is called deciding on the number of seats in the legislative bodies, not the Parliament. Then reservation for various categories, then distribution of reserved seats in such manner that complies with the number of seats available under the category in legislative assembly and the Parliament. So these are the areas of jurisdiction of the Act. Now delimitation word we are listening number of times. There can be a confusion what does delimitation means, or that requires a clarity. First thing is that there is a delimitation commission in India and there is a delimitation commission act 1952 and accordingly a delimitation commission is there. They decide this delimitation. What is that? Delimitation of constituency, and in this case authority's decision is final. Sometimes previous questions come that can the decisions on delimitation by the delimitation commission be challenged, be changed by Parliament? No. So it is the authority's decision is final. Delimitation is done based on census report. Fine. This source is census report 1971, 1991, 2011. It goes like that. Right now 1991 has been made the periodical census on which it will be done. Then delimitation commission was born out of Parliamentary Act. It is not a constitutional body. It is a legal body because it has been done through a Parliamentary Act. What is the constitutional provisions on delimitations? Article 81(3), last published population census report is the index. So that is what the Constitution says, last published population index report is the index. Accordingly, now we have 1911 published report. Therefore, 1911 will be the index for delimitation, but 84 and 74 they have talked about 1991 and 1971, but Constitution says that this will be, that means 2011 will be the index found, what you call base. 174 it says that session, prorogation, dissolution of state legislatures, so it talks about that. 329 it bar of interference by court in election matters. Election matters, court will not unnecessarily interfere. This absolutely goes with the election commission. If there is an election related dispute, then that will come to the court, but otherwise court will not intervene into the functioning of the election commission. 42nd Amendment Act 1976 and 84th Amendment Act 2008 freeze the number of legislatures. So as we said earlier, so it has freezed the number of legislatures. So therefore, no, the total number of legislatures will not be increased, but delimitation will be done according to the latest published report of the census, which is definitely 2011. RP Act 1951 section 13 it says procedure for delimitation must be placed before Parliament. Now the delimitation cannot be just done arbitrarily by delimitation commission. Whatever they are thinking about delimitation, that must be placed before the Parliament, so that Parliament is informed that how this delimitation is taking place and which are the parameters followed for delimitation. Now see the questions. Then you will understand that these questions can be answered. It is a 2020 question. 2020 a question came. There is a need for simplification of procedure for disqualification of persons found guilty of corrupt practices under the Representation of People Act. Comment. So this simplification of procedures for disqualification should be done, particularly when somebody is found guilty of corrupt practices. That means so much inquiry, all this, if it is taking too long a time until it is concluded, then disqualification cannot be done by the time this person might complete or may complete his whole session. So that is why it says that it must be simplified, it must be expedited. Second one is 2019 question, on what grounds a people's representative can be disqualified under the Representative of People Act. So already I have said, and you just give those lists, okay, and then explain a bit, and you will see that your answer is already ready with a bit of introduction and certainly the estimation. Also mention the remedies available to such persons against his disqualification. Now there are certain disqualification he can remain, for example, he has not submitted ITR for his election expenses, so he cannot submit ITR, and the moment he submits, then he is not disqualified by that. Or if he has entered into a contract with any government departments, he can just come out of that contract, or that contract he can cancel. So immediately that impact of that contract does not bear on him. So that way, so a person can reduce disqualification or get rid of disqualification. This is in brief my introduction about these two acts. I believe that it will help you, the information that you have got. And if you have any comment or you need further information, further clarification, please get back to us through the commentary box. Thank you very much.